Okay. Okay. The purpose of our court system is to maintain peace, preserve the individual rights of the citizens, but above all, the court system's main focus should be enacting justice. The purpose of rehabilitation is to incarcerate, punish, but ultimately reintegrate criminals back into society. Does the death penalty actually accomplish this goal? While many states still practice the death penalty, many others have outlawed it or heavily discouraged it. Over the past century, advocates and legislatures have come to the conclusion that the death penalty is not only unconstitutional, discriminatory, but is very, very costly on the state. In recent years, the United States has experienced a notable decline in public opinion approving of capital punishment. This is due to the constitutionality of the practice. The death penalty inherently violates the constitutional ban against cruel and unusual punishment under the Eighth Amendment. Although capital punishment has been practiced in several states for centuries, this constitutionality of capital punishment was never discussed until the landmark Supreme Court case Furman v. Georgia. This court case called into question whether the imposition of capital punishment was violating the Eighth Amendment. William Furman was in the process of committing a burglary. He accidentally dropped his gun, which led to the death of a person pursuing him. He was convicted of murder and was eventually put to the death penalty. Was placed on death penalty, but after appealing to the Supreme Court, he eventually was deferred. In a 5-4 decision, the Supreme Court held that imposition of capital punishment in this case constituted as cruel and unusual punishment and violated the Constitution. But this ruling was overturned in 1976 due to a series of Supreme Court cases, but the court continued to address the constitutionality of capital punishment in special contexts. This was again addressed in Atkins v. Virginia. In this case, Darrell Atkins was convicted of capital murder during an armed robbery very similar to Furman. But due to his mental retardation, the court ruled that this would be cruel and unusual punishment. But due to the Atkins v. Virginia case reveals the issue with capital punishment even further. The Supreme Court justices concluded that capital punishment was excessive due to the fact that the criminal was mentally retarded, but mental deficiencies do not warrant citizens' exemption from criminal prosecutions under the law. Therefore, the reasoning behind the ruling was that capital punishment in and of itself is cruel and unusual punishment. Thus, it violates the Eighth Amendment. If capital punishment in and of itself is cruel and unusual punishment, then how is a mentally capable adult receiving the same punishment not cruel and unusual? These court cases exhibit a clear underlying problem with the practice of capital punishment and how it clearly conflicts with the Eighth Amendment. In addition to that, capital punishment disproportionately is administered to racial minorities and the poor. In the United States, the capital punishment has been long scrutinized for being racially biased. Studies have indicated that the race of the victim and the defendant plays a significant role in the question of who dies by execution. According to some studies, race can influence which cases are chosen for capital prosecution and which prosecutors are allowed to make the decision. This issue of racial bias was initially addressed in the Supreme Court case McCleskey v. Kemp. In this case, McCleskey was convicted of murdering a white police officer in Georgia and was sentenced to death. But McCleskey argued that a statistical study proved that the imposition of the death penalty in Georgia was biased to some extent on the victim's race and the race of the offender. This study found that black defendants who kill white victims are more likely to receive the death penalty in the state. Although the Supreme Court ruled in favor of Kemp, it was acknowledged that the state of Georgia did disproportionately administer capital punishment to black defendants. This was later addressed in the Supreme Court by Supreme Court Justice William Douglas. Douglas said, alone offered a sustained critique of the discriminatory administration of death penalty, quoting presidential study that had observed The death sentence is disproportionately imposed and carried out on the poor, the Negro, and the members of unpopular groups. One of the most significant factors in capital punishment convictions is the race of the victim and the race of the offender. Many studies have illustrated that capital punishment is sought more often against an offender who kills a white victim than a Hispanic or African American victim. In the 1990 GAO, or Government Accountability Office, reviewed over 25 studies on capital sentencing procedures. After reviewing the studies, they concluded that 82% of the studies found that the race of the victim influenced the likelihood of the defendant being charged with first degree or receiving capital punishment. The findings also confirmed that there was a pattern of racial disparities in these sentences. While there are comparable numbers of black and white murder victims in the United States, 77% of the people executed in 1976 were convicted of killing white victims, and only 13% were convicted of killing black victims. Moreover, African Americans are more likely to receive capital punishment for non-lethal offenses than whites across the United States. The non-lethal crimes that have most frequently led to black defendants receiving capital punishment is rape or attempted rape. This issue of racial disparity was further discussed in the landmark court case Cocker v. Georgia. In 1974, Elric Cocker escaped from prison, raped a woman. As a result, he was sentenced to death. This case eventually took into the Supreme Court. The court ruled that capital punishment was disproportionate for the crime of rape. Although Coker was white, the history of capital cases pertaining to rape was linked to black men. Historically, the use of capital punishment has been fiercely enforced against black defendants, particularly in cases involving charges of raping a white woman. The practice originated in the antebellum South and had became established as law shortly after the Civil War. Many of the cases involving black men accused of raping white women were often lacking reliable witnesses, testimonies, protection, and physical evidence for many of these accusations of rape alone. In 1973, Marvin Wolfgang and Mark Riedel published a research article on the death penalty convictions. The research team analyzed 11 states and the death penalty convictions to find any correlations between race and conviction. According to statistics, black defendants were convicted of raping whites received the death penalty in 36% of the cases, while the comparable rates for blacks convicted of raping blacks and whites raping whites was up to 2%. While race was an explicit factor in the ruling of these cases, the court's decision, Coker v. Georgia, was highlighted the racial disparity in the death sentences for rape.